In today's video, we look back at some of the most striking death penalty cases of 2025. These cases span decades, involving acts of extreme violence, allegations of racial bias, and verdicts shaped by courts that moved painfully slow. Some of these sentences were handed down a generation ago, yet only now reach their final chapter. And that brings us to the central question. Do you believe justice remains intact after decades of delay? Where is the voice for the victims? Marian Bowman Jr., State, South Carolina, 44 years old. Marian Bowman Jr.'s case stands as one of the most contested and emotionally charged executions carried out in South Carolina in 2025. Born and raised in a state long shadowed by racial tension, Bowman entered the criminal justice system at 20 years old and would ultimately spend 24 years waiting for the state to take his life. His story begins on February 16, 2001, when a dispute over a small debt between Bowman and 21-year-old Candy Louise Martin spiraled into a deadly encounter. According to the state, the argument escalated in a wooded area where Bowman allegedly shot Candy multiple times, dragged her body, stuffed it into the trunk of a car, and drove to an isolated spot. There, prosecutors said, he set both the car and her body on fire in an attempt to destroy the evidence. Witnesses later reported hearing Bowman boast about the killing, while one recollected an ominous remark he allegedly made earlier that same day. "She'll be dead before nightfall." The evidence that ultimately sent him to death row rested heavily on the testimony of his cousin, James Taiwan Gadsden. Gadsden claimed he witnessed the murder, insisted Bowman had premeditated the act, and became the central pillar of the prosecution's narrative. Investigators also recovered a gun from a nearby river. Ballistics and DNA testing linked it to the crime, and no credible alibi placed Bowman anywhere else at the time. For the state, the case appeared airtight. For Bowman, it was a foundation built on sand. From the moment of his arrest until the final hour of his life, he maintained his innocence with a consistency that never wavered. "I am not guilty and would not claim something I didn't do," he repeated for more than 2 decades, refusing to confess even when death was certain. The biggest fractures in the case, and the source of its deepest controversy, emerged not from the crime scene, but from the courtroom itself. Defense attorneys and later appellate lawyers argued that crucial evidence had been withheld, most notably a memo indicating that another witness had privately confessed to firing the fatal shots. If true, this would constitute a Brady violation, one of the most serious forms of prosecutorial misconduct, as it involves suppressing evidence favorable to the defendant. Gadsden's testimony, the backbone of the state's case, was also contested. His statements had shifted over time, and he had his own incentives, critics argued, to reduce his culpability by placing full responsibility on Bowman. Yet these concerns never persuaded the courts to reopen the case. An additional layer of controversy surrounded the defense attorney's conduct at trial. Multiple appeals argued that Bowman's own lawyer used racially charged language, describing him as having predatory behavior, being gang-minded, or portraying him as a dangerous young black male. In a state with a long, painful history of racialized punishment, such language echoed long-standing stereotypes that could prime a jury toward fear rather than deliberation. South Carolina's death penalty record only intensified these concerns at the time. Black defendants were being sentenced to death at disproportionately high rates, even in cases where white defendants with similar charges faced lesser sentences. Civil rights groups monitoring capital punishment argued that Bowman's trial unfolded inside a justice system structurally predisposed to view him through a lens of suspicion and threat. For them, Bowman was not merely an individual defendant, he was a symbol of systemic bias. The length of Bowman's path to execution became another point of ethical dispute. From 2001 to 2025, he filed appeal after appeal, moving from state courts to federal courts and ultimately to the Fourth Circuit Court of Appeals. In 2022, that court rejected his final petition. The U.S. Supreme Court declined to hear the case. After that, Bowman's legal avenues were exhausted. Yet he still waited 3 more years for the state to schedule his execution, years spent in near total isolation on death row. Critics questioned what purpose such a drawn-out process served. A death sentence carried out more than 2 decades after the crime, they argued, blurred the line between punishment and psychological torment. Journalists repeatedly asked whether an execution delayed longer than the victim's lifespan could still meaningfully function as justice. Others wondered why the machinery of death moved so slowly for some individuals and so quickly for others, raising familiar concerns about consistency, fairness, and political influence. On January 31, 2025, South Carolina carried out the execution of 44-year-old Marian Bowman Jr. His final hours contrasted sharply with the grim austerity of death row. His last meal resembled a feast: fried seafood, chicken wings, onion rings, banana pudding, German chocolate cake, cranberry juice, and pineapple juice. The abundance of the tray sat awkwardly beside the sterile certainty of what awaited him. When the execution chamber curtains opened around 6 p.m., Bowman looked toward his attorneys and nodded. He had asked them to read his final statement. In it, he once again declared, "I did not kill Candy Martin. I'm innocent of the crimes I'm here to die for." He spoke of the decades spent in isolation, of a system he described as profoundly unjust, and of the burden carried by his loved ones. But he also expressed a quiet hope that, if his death brought even a measure of comfort to the Martin family, they would find peace. Bowman refused to request clemency. Accepting a reduction to life in prison, he said, would be admitting guilt, and he would not confess to something he had not done. By the time the state pronounced him dead, Bowman had spent more than half his life under a sentence he insisted was built on bias and concealment. His execution remains a point of ongoing debate among legal scholars, activists, and community members, raising enduring questions about fairness, accountability, and the long shadow of race in American justice. Was this truly justice after 24 years, and under so much alleged bias? James Dennis Ford, State, Florida, 64 years old. James Dennis Ford's case is one of the longest and most contested death row journeys in modern Florida history, stretching 26 years from conviction to execution. The crime itself, committed in 1997, involved the deaths of Greg and Kimberly Mallory, a young couple whose toddler was found alive 16 hours later in their blood-soaked vehicle, a detail that shocked the community and fueled public outrage. But beyond the horrific nature of the case, what followed was more than 2 decades of legal battles, appeals, and Ford's unwavering insistence that he had been framed. While Florida prosecutors portrayed him as the sole perpetrator of a brutal double homicide, Ford maintained from the beginning that he had been set up, and that someone else was responsible, a position he refused to abandon even when facing imminent execution. Ford's legal odyssey began in 1999, when a Florida jury moved swiftly to convict him. The prosecution presented DNA evidence, forensic interpretations, and scene analysis that suggested Ford's involvement, along with the emotionally powerful fact that the Mallory's child had survived 18 hours alone. The trial advanced faster than many capital cases, and the death sentence was imposed within the year. Yet Ford rejected the state's narrative from the first day, telling the court he had been a pawn in a larger situation, and that investigators had overlooked critical leads pointing toward another suspect. From 1999 to 2006, Ford pursued state-level appeals, arguing that police had coerced his statements, that the DNA evidence had been misread or overstated, and that prosecutors had oversold the narrative to inflame the jury. His defense insisted he had no personal motive, that another individual could have committed the crime, and that the forensic results did not rule out accidental transfer. Every challenge was denied. Appellate judges repeatedly affirmed that the conviction met the legal standards of the time, and that none of the issues raised undermined the reliability of the verdict. The case then entered federal court, where Ford filed a habeas corpus petition between 2006 and 2012. His arguments shifted toward constitutional violations, ineffective assistance of counsel under the Sixth Amendment, emotionally charged rhetoric by the prosecution, and misleading interpretations of physical evidence. In federal filings, his attorneys described the case as one shaped more by emotion than by impartial analysis. But the federal courts found no reversible error. They ruled that none of Ford's claims met the threshold for overturning the sentence, and that the capital conviction had followed procedures consistent with constitutional requirements. Still, Ford continued to assert that he was simply a man in the wrong place at the wrong time, and that the state had built a narrative that ignored alternative suspects. Between 2012 and 2024, Ford's case entered its longest and most stagnant phase. He submitted petitions referencing his age, medical concerns, evolving constitutional standards, and advancements in forensic technology. He asked for retesting of old evidence, argued for reconsideration of his constitutional claims, and pointed to alleged discrepancies that had not been fully explored. Courts, however, remained consistent. None of the proposed issues warranted reopening the case. Despite the lack of legal progress, Ford never shifted his position. He maintained his innocence, rejected plea deals, and refused to express remorse for acts he said he did not commit. A turning point came in 2025, when Governor Ron DeSantis, after years in which Florida carried out very few executions, signed Ford's death warrant. The decision effectively ended Ford's 26-year legal struggle. Even in the face of a definitive execution date, Ford declined to request clemency. In his words, "I cannot seek mercy for a crime I did not commit." He chose death over what he viewed as a coerced admission of guilt. In the final hours of his life, Ford's demeanor was described by prison officials as polite, quiet, and composed. His last meal was unremarkable: cheeseburger, fries, fried shrimp, a vanilla milkshake, and sweet tea. Simple comfort foods rather than the elaborate requests some inmates make. Staff noted that he thanked them and showed no signs of agitation or fear. Just before the lethal chemicals flowed, Ford was offered a chance to speak. He did. "I stand here innocent of what I was convicted of," he said firmly. "I pray the truth will one day be known." He also acknowledged the suffering endured by the Mallory family, though he maintained that he was not the cause of their grief. Observers described him as calm, steady, and resolute, holding to his claim of innocence until the final breath. Ford died insisting that the state had executed the wrong man, a claim that will likely continue to be debated for years as part of Florida's complex history with the death penalty. Was justice truly served after decades of delay and disputed guilt? Stephen LaWayne Nelson, State, Texas, 37 years old. Stephen LaWayne Nelson's case is one of the most chilling and heavily documented capital murders in Texas, a story defined not only by a brutal crime inside a church, but by a long trail of violence, instability, and legal battles that stretched across 13 years before the state finally carried out his execution. Born in 1987, Nelson grew up in a fractured environment marked by instability, family conflict, and early behavioral problems. He was arrested for the first time while still a teenager, and his criminal history escalated through his 20s: theft, violent outbursts, assaults, and a reputation for impulsive, explosive aggression. At the time of the 2011 crime that would seal his fate, he was on probation for assaulting his girlfriend, already identified as a high-risk offender whose behavior repeatedly spiraled beyond the control of family or probation officers. Behavioral analysts and forensic psychologists later described him as an individual who thrived on intimidation, whose sense of dominance was closely tied to violence, and whose impulsivity made him unpredictable. On March 3, 2011, Nelson entered the North Point Baptist Church in Arlington, Texas, intending to rob the building. Inside were only two people: Reverend Clint Dobson, 28, and Church Secretary Judy Elliott, 69. What began as robbery quickly transitioned into prolonged violence. Dobson was tied, beaten, strangled, and ultimately suffocated when Nelson forced a plastic bag over his head. Elliott was assaulted with multiple blows to the head, suffering skull fractures, facial fractures, and traumatic brain injury, injuries so severe that doctors described her survival as remarkable. She later testified against Nelson. After leaving the church, Nelson took the pastor's laptop, Elliot's credit cards, the pastor's car, and used the stolen cards to buy clothing and jewelry. His casual purchases in the hours after the crime, captured by store cameras, became part of the state's narrative of a man without remorse. The evidence against Nelson was substantial and multidimensional. His fingerprints were recovered inside the church. His shoe prints matched blood-marked impressions at the scene, and blood was found on his shoes at the time of his arrest. Surveillance footage documented him using Elliot's credit card and selling the pastor's laptop. Witnesses, including an acquaintance who had been with him earlier, reported that Nelson bragged about overpowering the two church workers. A pawnshop employee recalled him trying to offload the laptop in a manner that appeared panicked and disorganized. Physical evidence, testimonial evidence, and digital footprints aligned into a prosecutorial case that left little room for doubt. When Nelson went to trial in 2012, the courtroom atmosphere was tense. Judy Elliott, still visibly affected by her injuries, testified about the attack. Prosecutors played 9-to-1 audio, presented forensic reconstructions, and told jurors that Nelson smiled during descriptions of the pastor's final moments. Nelson's behavior in the courtroom became part of the record. He disrupted proceedings, shouted at guards, and on multiple occasions had to be restrained. Jurors saw both the evidence and the demeanor of a man many believed had no regard for life or the law. The jury unanimously sentenced him to death. For more than a decade, Nelson appealed the conviction and sentence. His attorneys argued that his mental health history should have carried more mitigating weight, that childhood instability had fueled his adult behavior, and that the trial court should not have admitted certain evidence regarding his prior conduct. They further argued that the introduction of his post-conviction prison infractions unfairly prejudiced the jury. These appeals moved through the Texas Court of Criminal Appeals and later the Fifth Circuit Court of Appeals, but every filing was rejected. Judges consistently wrote that the weight of the evidence, combined with Nelson's conduct, supported the capital sentence. Despite the lengthy timeline of the appeals process, no new evidence or procedural error emerged that could reopen the case. Nelson's time on death row was volatile and punctuated by violent behavior. He assaulted correctional officers, broke fixtures inside his cell, attempted to choke a guard through the door slot, and threatened to do it again if ever released. Staff routinely classified him as high risk. One officer wrote, "Nelson is a danger to anyone within arm's reach." His disciplinary record undermined nearly all arguments for resentencing. It also reinforced the prosecution's final claim that Nelson continued to pose an extreme threat. On February 5, 2025, the state of Texas executed Stephen LaWayne Nelson at age 37. He declined a special last meal, ate nothing out of the ordinary, and had no family members present. He refused to give a final statement. Witnesses described him as expressionless, rigid, and defiant in silence. As the curtain opened and the lethal injection process began, he stared straight through the glass, offering neither apology nor acknowledgement. Observers later described him as calm but unrepentant, a man who carried the same cold detachment seen throughout his case. Nelson's execution closed a 13-year legal saga marked by overwhelming evidence, repeated acts of violence, and appeals that failed to shift the original judgment. Yet questions remain: that is mental health a legitimate excuse to hurt others? And if so, what did the victims die for? Percy Hutton, State of Ohio, 63 years old. Percy Hutton's case stands as one of the longest-running and most legally complex capital cases in Ohio's modern history. Born in 1962 and raised in Cleveland, Hutton grew up without a record of serious violence, but was known in his neighborhood as irritable, quick to argue, and often caught in personal disputes. He was closely acquainted with brothers Samuel Simmons Jr. and Derek Mitchell, both familiar faces in the community. The relationship fractured when Hutton became convinced that Simmons and Mitchell had stolen machinery and tires from his home. Feeling betrayed, he vowed to handle it. If he ever discovered who was responsible, an escalating tension that would soon lead to deadly consequences. On September 16, 1985, Hutton and his brother-in-law Bruce Porter drove to Simmons' home to confront him. When they encountered Simmons and Mitchell, Hutton accused them of theft and forced both men into his car, driving them to a deserted parking lot. What happened next became the central dispute of the case. Simmons was shot twice in the head, but miraculously survived long enough to crawl for help. Mitchell was shot and killed, his body discovered shortly afterward. Hutton returned to the scene and attempted to spin a narrative that an unknown attacker had ambushed them, even taking Simmons to the hospital in an effort to portray himself as a helper rather than the shooter. Detectives quickly grew suspicious. Hutton's version of events changed multiple times, and inconsistencies accumulated almost immediately. At trial in 1986, the prosecution relied heavily on Simmons' survival and eyewitness identification. Despite his head injuries, Simmons insisted from his hospital bed that Hutton was the shooter. Ballistics showed that the bullets recovered from Simmons and from Mitchell's body were the same caliber, consistent with a single weapon fired in similar fashion. Prosecutors emphasized the clear motive, anger over theft, and Hutton's shifting explanations. Hutton, lacking an alibi or alternative suspect other than vague references to strangers, was convicted of aggravated murder and sentenced to death. What followed was nearly 4 decades of litigation. Between 1986 and 2001, Hutton filed appeal after appeal. He argued that his Sixth Amendment rights were violated because his trial counsel failed to investigate alternative suspects. He claimed Simmons' identification was unreliable due to severe head trauma. He challenged the absence of a recovered murder weapon and accused prosecutors of inflaming the jury by portraying him as dangerously unpredictable. Every argument was rejected by Ohio appellate courts, which upheld the conviction as legally sound. From 2001 to 2010, the case shifted to the federal level, where Hutton filed for habeas corpus relief. Here he shifted blame directly to Porter, asserting that his brother-in-law had fired the shots. He argued that police never seriously investigated Porter or anyone else. His legal team insisted that Simmons' traumatic brain injury made his identification fundamentally flawed, and that prosecutors' emotionally charged closing arguments misled the jury. Yet federal judges concluded that none of these claims met the high burden required to overturn a capital conviction. The court deemed the evidence consistent with the verdict and found no constitutional violations severe enough to warrant relief. From 2010 through 2022, the legal battle took on a different tone, not because of new facts, but because the state of Ohio simply could not carry out executions. Drug shortages, legal challenges to lethal injection, and pharmaceutical companies refusing to supply chemicals placed the death penalty on an unofficial pause. Hutton's execution, originally scheduled for June 22, 2022, was postponed multiple times by Governor Mike DeWine, who stated that Ohio could not, responsibly or safely, conduct executions under current drug constraints. This logistical limbo extended Hutton's time on death row by more than a decade, and intensified debate over whether such long delays constituted cruel and unusual punishment. Throughout these decades, Hutton never abandoned his innocence claims. He insisted, "I didn't shoot Mitchell," and "I just wanted to confront them about what was stolen." He said he never intended to kill anyone. His defense repeatedly emphasized that Simmons' head trauma could have distorted memory, that Hutton's intention was intimidation, not murder, and that Porter should have been scrutinized more aggressively. Despite these efforts, courts consistently ruled that the evidence, especially Simmons' detailed identification and the circumstances surrounding the shooting, met the legal threshold for capital punishment. The case attracted growing controversy as Hutton aged. Human rights organizations pointed to his declining health, his long-term isolation, and the nearly 4-decade gap between sentencing and planned execution as signs that the death penalty had lost any legitimate purpose. Legal scholars questioned whether the crime reflected premeditated capital murder or a violent confrontation that escalated in the moment. An important distinction in Ohio's sentencing framework. By the time Ohio scheduled his execution for June 18, 2025, Hutton was 63, physically deteriorated, and had spent the majority of his life under a sentence whose outcome the state repeatedly failed to carry out. Percy Hutton's case remains a stark illustration of the complexity, delays, and unanswered questions embedded in America's death penalty system, where guilt and intent are argued for decades, and where final judgments often arrive long after the truth has faded into memory. Was justice served after 40 years of delay, or distorted by doubt? Moises Sandoval Mendoza, State, Texas, 40 years old. Moises Sandoval Mendoza's case is a stark reminder of how quickly a young life, barely entering adulthood, can spiral into a violent tragedy with irreversible consequences. Born in 1985 in Texas, Mendoza grew up in a family-centered neighborhood and worked odd jobs throughout his teens. Although he never accumulated a serious criminal record, those who knew him described a young man marked by volatility, quiet one moment, suddenly explosive the next. Police reports documented several instances of aggression in personal relationships, but none escalated to the level that would justify prosecution. By the time he reached 19, Mendoza already fit the profile of someone struggling with impulse control, emotional instability, and a tendency to lash out. In 2004, when the crime occurred, he was just beginning adult life, but prosecutors would soon portray him as someone capable of extreme brutality. The events of March 2004 unfolded in Collin County, Texas, when a 20-year-old woman went missing. Mendoza was among the last people seen with her, and the story he would eventually give police shifted with every retelling. According to the case file, investigators concluded that Mendoza strangled the victim either inside his home or in a nearby location, instead of calling for help or reporting an accident. As he later claimed during appeals, he hid the body behind his house, allowing it to decompose for days. When the smell began drawing unwanted attention from neighbors and intensified the risk of discovery, Mendoza dug up the decaying remains, transported them to a rural well, set the body on fire, and buried it beneath dry brush. Prosecutors emphasized that this wasn't a spontaneous concealment attempt, but a series of calculated decisions carried out over multiple days, actions they said revealed a consciousness of guilt far beyond panic. The investigation quickly tightened around Mendoza. As police searched the area where the victim had last been seen, Mendoza's behavior raised suspicion. He gave conflicting statements about when he had last interacted with her. Neighbors reported a strange odor emanating from behind his house, and when asked, Mendoza stumbled over explanations that investigators found implausible. Forensic teams recovered items from the well, charred debris and personal belongings that matched those of the victim. The physical evidence strengthened when fingerprint and DNA traces linked Mendoza directly to the location where the body had been burned and buried. Indicators at the original scene suggested that the victim had died near Mendoza's property before being relocated. To detectives and later, to prosecutors, the fact that Mendoza hid the body, dug it up, moved it, burned it, and buried it again demonstrated deliberate, purposeful concealment. No other suspect emerged, and the circumstantial evidence formed a coherent narrative pointing squarely at Mendoza. His trial began in June 2005, and the evidence presented to the jury painted a grim picture. Jurors heard about the strangulation, the prolonged attempt to obscure the body, and the series of lies Mendoza offered during questioning. They heard that he showed no remorse, no fear, no visible distress, only evasion. Prosecutors argued that the manual strangulation demonstrated close, personal violence requiring control and intention. The extended concealment, they said, showed forethought and self-preservation, not accident or panic. The defense countered by highlighting Mendoza's youth, emotional immaturity, and lack of a violent criminal past. They maintained that the events that led to the woman's death may have been an accident during a struggle, and that Mendoza's bizarre behavior afterward stemmed from fear rather than malice. The jury was not persuaded. On June 23, 2005, Mendoza was convicted of capital murder. In recommending the death penalty, the jury cited several factors: the brutality of the killing, the complex two-stage disposal process, the absence of remorse, and the danger they believed he posed to others. Over the next 20 years, Mendoza's appeals would circle through the Texas court system and the federal system with little momentum. His attorneys filed motions claiming ineffective assistance of counsel, arguing that the defense had failed to question certain witnesses or present alternative theories. They insisted that the state's case lacked direct eyewitness testimony and relied on inferences pieced together through forensic interpretation. They argued that the body's advanced decomposition and burning rendered cause of death uncertain, raising the possibility of an accidental death. Yet every appellate court reached the same conclusion. Even without a definitive autopsy, the mountain of circumstantial evidence and Mendoza's own incriminating behavior provided overwhelming support for the conviction. The Texas Court of Criminal Appeals upheld the death sentence in 2008, and subsequent petitions between 2009 and 2024 failed to introduce new evidence or demonstrate any constitutional violations. Compared with other Texas death row cases, Mendoza's was legally stable, consistent, and largely uncontested by the courts. During his 2 decades on death row, Mendoza reportedly lived quietly. Prison staff described him as calm, withdrawn, and largely compliant. Records indicate he struggled with depression and anxiety, but never engaged in violent behavior while incarcerated. He maintained his innocence, insisting, "I didn't kill her. I panicked, but I didn't kill her." Yet the courts viewed his claims as contradictory, especially given the extensive steps he took to hide the body. Without new evidence, his appeals remained procedural rather than substantive. On April 23, 2025, the state of Texas executed Moises Sandoval Mendoza by lethal injection at the Huntsville unit. No last-minute appeals were filed. His final meal and last statement were not made public. Members of the victim's family attended, though they chose not to speak publicly afterward. Prison officials described Mendoza as quiet, composed, and showing no outward sign of panic, a stark contrast to the violence he was convicted of committing at 19. His execution closes a chapter that leaves behind conflicting interpretations: a young man who committed an act of chilling brutality, or a troubled youth whose panic spiraled into irreversible harm. How does someone so young transform into something so terrifying?